Okay, come on.
Can't decide what I want to do.
Okay, so there's that. No, you're fine. Yeah, you're good. I can see
Okay.
you just fine and everything. Are you okay with how everything's set up?
I think so now.
Okay. Okay. So I'm going to start the recording. Okay. Now let's just start asking questions. Kim, what should I look for in a DUI defense attorney?
What you should look for in a DWI defense attorney is someone who not only has experience and has been doing specifically DWI defense work for years, but someone who considers themselves always a student, attending seminars, learning all the new science, learning all the new techniques, making sure they're updated on the law, attending the national programs. Here at our law firm, we are very involved with the National College for DUI Defense, for which I sit on the faculty and I'm currently on the board for. And we are able to attend the most current science programs in order to understand exactly how to win our DWI cases when it comes to the breath tests and the blood tests. And we're also very active in learning how to cross-examine police officers, because that's another avenue of a way to win a DWI case, is that you are very familiar with what is the training the officers received by NHTSA, the National Highway Traffic Safety Administration, or how to cross-examine them based on the fact that most officers do not comply with their training. And that is really ideally what you would find in a defense attorney. Also someone who says that they try cases, that they've talked to juries and they've talked to judges about DWI defense cases, not someone who pleads your case right away without doing a full investigation and without understanding the law and the science, and someone who doesn't watch the videos. That's another thing to be on the lookout for. If I had a checklist, it would be that they investigate my case, they do a full discovery and watch all the videos and read all the police reports in my case, that they know the officers, the prosecutors, the judges in this particular jurisdiction, and they know what the training is of a police officer, and they know how to beat a breath test and how to beat a blood test, because those are very weak issues that the prosecution has in their case that we take advantage of because we attend the programs and we know how to beat the case.
When should I hire a DUI lawyer after being arrested? It's DWI, isn't it? When should I hire a DWI lawyer after being arrested?
You should hire a DWI lawyer very shortly after being arrested. And the reason is twofold. One is your driver's license case. It has a very strict deadline, and we do not have any extensions to that deadline. If you provided a breath sample, you have 15 days to fight your driver's license case. Even if you don't think you should fight the driver's license case, a good lawyer knows that that's how we win the ultimate we win the driver's license case, or we fight in the driver's license case in order to win the DWI case. So a good lawyer knows how to try that case, how to prepare that case, and how to set that case up for whether it's a win or a loss to do better in the criminal case. So definitely within a few days of your arrest. The deadline, the strict deadline, is 15 days from providing that breath test. If you refused, you're going to lose your license in 15 days, but we at least have a longer window to file the lawsuit. That window is 30 days. And that allows us, filing that lawsuit, whether you think you should fight your driver's license case or not, whether you think you have a defense or not, we always file those cases because it's in those cases, the driver's license cases, that we get the ammunition and we get our success in winning the DWI.
Do I need a lawyer if I've been arrested for a DWI?
The question we often get is, do I even need a lawyer if I have a DWI? What if I knew that I was intoxicated and was driving, or feel that I was intoxicated? The reality is, a good lawyer who knows what they're doing will look at your case objectively and potentially win your case. We have won cases where our clients had a blood test over 0.50. That is a person who should not have even survived potentially that much alcohol in their system. We've won the driver's license cases, and when clients thought that they were going to lose, we have won the DWI case when the client thought they were going to lose. There are so many reasons that a lawyer, a good lawyer who knows the science and knows the law and knows the training that the officers have used and have done the training themselves, preferably someone who, like in our law firm, does the training very often and periodically, not just does it once and calls it good, but someone who understands the training, knows how to cross-examine police officers specifically on their training and on their arrest decision, and also knows how to beat a breath test and beat a blood test, because the science, there is a lot of information by knowing the science that allows you to challenge a DWI.
What defenses are commonly used in DWI cases?
The defenses that are commonly used in a DWI defense case are defenses that are focused on the officer's credibility and the officer's investigation. In addition to knowing the science about the breath test and or the blood test, some people have both a breath test and a blood test, and some people just have one or the other or a refusal. But knowing the law and knowing the science and knowing how to cross-examine a police officer based on their training and the totality of whether the person was intoxicated or not. What we see a lot of is someone who the officer writes a report and it sounds horrible, sounds like the client is intoxicated. And then we get the video and we're like, well, they weren't slurring their words like you think they were, you say they were. They handled themselves very well with their balance and their finger dexterity, their communication. They understood what you were talking about and they answered your questions, and they were driving actually quite well. Someone who's speeding or has a license plate light out or a defective equipment like a tail light out, those are not signs of someone who's intoxicated while driving. And so we're looking at the totality of the case and looking for all the different reasons that the officer made a mistake, or the officer can't be believed or trusted, or the breath test can't be believed or trusted, or the blood test can't be believed or trusted.
What is the legal blood alcohol content for DWI in Missouri?
In Missouri, the DWI blood alcohol concentration threshold is 0.08. And what that means is if you provided a breath sample or a blood sample and it tested positive equal to or above 0.08 blood alcohol content, then it's presumed that you were driving while intoxicated, but it's a presumption. There is another statute in Missouri that allows a prosecutor to also charge you with what's called a BAC, which is blood alcohol content above the legal limit. That's a separate charge from driving while intoxicated. But either way, if a lawyer knows how to beat the blood test or the breath test, or if the lawyer is able to beat that presumption, in other words, the presumption in the DWI is that you're intoxicated if it's above a 0.08. However, if there's video or there's credibility issues with the officers, and there's reasons the officer shouldn't have stopped you in the first place, or they shouldn't have arrested you because we have analyzed how they handled your case and your investigation compared to how they've been trained, then we can often win those cases.
Can a person get a DWI if their BAC is below the legal limit?
Unfortunately, in Missouri, we have seen prosecutors and police officers file charges. The prosecutor files the charge, the officer does the arrest and gives you the ticket. When someone's blood alcohol content is below a 0.08, we've seen it. We've had to defend those clients. We've had clients where the prosecutor digs their heels in and says this person's intoxicated regardless of the blood alcohol content. And we've had cases where the prosecutor says, okay, I agree, this person was not impaired or intoxicated, and we will amend the charge or dismiss the charge. I just want you to think about this. If you did not provide a breath sample or a blood sample, and the prosecutor has nothing but a police officer who says, this is the way they were driving, this is the way they appeared, this is the way they presented when it comes to their balance and their speech and their comprehension, and then you refused to provide a blood test or a breath test, they still can charge you with a DWI, and a jury or a judge could still find you guilty of that DWI. So it's not the only way a prosecutor can make their case. It's not the only way you can be convicted of a DWI.
So then, should I always take the roadside tests if I am involved in a traffic stop?
The question is, should I always take the roadside tests if I'm involved in a traffic stop when the officer has asked me out of the vehicle to perform what's called the standardized field sobriety test, or any field sobriety test? There's 3 that are standardized. They're the ones that people talk about the most. It's the horizontal gaze nystagmus, where you see an officer take a finger or a pen or something and they're checking your eyes. There's the walk and turn, where you're walking down 9 steps, you're doing a certain type of turn, you're walking back 9 steps. And then there's the one leg stand, which is how it sounds. You're standing on your one leg. You absolutely have the right to say you do not want to take those tests. They can't force you to. What's helpful to us in your defense is if you, on video, hopefully, because they have body cameras and they have dash cameras. If you are, and hopefully they've written notes being accurate if you don't have any camera footage. But if you are explaining why you can't do it, you have a right to say, I have recently had knee surgery, or I have a bad back, or I can't stand on one leg for whatever reason. Some people have a disorder like Meniere's disease, which is essentially a really serious vertigo. There are plenty of reasons that you can say, no, I don't want to do it, with a valid excuse, or you can just simply say, I don't want to do it, and I will not take your test because I don't trust the test and I don't trust you to perform the test properly. However, I will say this. For as much as we hear lawyers telling people don't do it, don't take the test, refuse to talk, and all those things, the way we win so many of our cases is because you did submit. You appeared sober. Signs of sobriety are the way we win so many of these cases, because when the officer writes the report and they say they were slurring their words and their balance was off and they're swaying when standing, and the officer is saying all these negative things about you, and then we get the video and it shows that the officer is exaggerating or lying. That's how we win so many of these cases. So there's no black and white, do or don't submit to those tests, but you have the right not to.
What happens during a traffic stop?
What happens during a traffic stop is that the officer has started by observing your driving, and they are behind you, usually running your plates, determining that they're going to pull you over. And if they see prior DWIs, prior alcohol content with law enforcement, then their antenna's up and they're more likely to pull you over. And they can pull you over whether they see a moving violation or they see any other kind of traffic violation, such as you have the license plate light above your license plate. It's supposed to be lit. Your license plate is supposed to be illuminated for them. You're supposed to have minimum two tail lights. You're supposed to have 2 headlights. So if they see any reason, defective equipment or a moving violation to pull you over, they get to pull you over. And so they're observing how you're driving, and then they are going to reach, after they pull you over, they're going to be watching how you pull over, by the way, how quickly you pull over, how easily you pull over. Do you hit the curb? Do you stop in the middle of the roadway, or do you pull to the side, or do you safely pull to maybe a driveway or something, or a parking lot? How long it takes you to stop. Do you just keep driving and driving as if you didn't notice them, which could be the sign of an intoxication, or it could be the sign of just not paying attention. But nonetheless, they're paying attention to all of that. And then they are going to be observing you as they walk up to your vehicle and they stand outside your vehicle. They're going to give you orders or ask you questions. And those questions are designed not because they're curious. They're designed to investigate you. They're designed to determine, is this a person who I'm just going to issue that speeding ticket to potentially, or is this a person that has been drinking and driving? And their antenna has gone up if they found a prior on your driving record as they were asking dispatch to tell them about you while they were following you, or if they approach the vehicle and you're acting suspicious in any way, or you smell suspicious. If they can smell alcohol, their antennas are going to go up. They're going to start asking you questions. You don't have to answer any of those questions, but that's what's going to happen at the beginning of a traffic stop. And if they decide they're going to investigate you for DWI, they're going to continue along their training, which is asking you out of the vehicle, asking you to perform field sobriety tests, and asking you to provide maybe a preliminary breath test there at the roadside, and ultimately an official breath test that is not the preliminary breath test, but an official breath test, which in some jurisdictions can be done roadside, or most of the time it's back at the station after you've technically been arrested is when they're supposed to do that.
Can I refuse the test at the station?
You have the right to refuse the breath test back at the station, the official breath test. You have the right to refuse that preliminary breath test that they asked you to perform field side or roadside. But if you refuse, there are consequences for your actions. They are required to read what's known in Missouri as implied consent law, and they are not required to tell you you have a right to a lawyer. So you should always talk about early and often your desire to talk to a lawyer. When do I get to talk to a lawyer? Ask that question immediately. The minute they ask you out of your vehicle, when do I get to talk to a lawyer? They have you doing the field sobriety test and you decide to say yes or no. Either way, when do I get to talk to a lawyer? And they're required in Missouri, after they read you the implied consent, to give you a 20-minute opportunity to try to call a lawyer. Often what happens is they put you in a room with a phone, a landline, and a phone book, which in this day and age in 2026 is not the best way to find a lawyer or reach a lawyer. In some jurisdictions, they're very kind to you because they understand that phone books barely exist anymore for lawyers, and that you are going to have access to your cell phone in order to try to reach a lawyer. And but you have the right to talk to a lawyer at that point and have a 20-minute opportunity. If you fail to reach a lawyer at that point, you have to make your decision. Or if you do reach the lawyer, you still have to make your decision. You just have 20 minutes. And then you say, I refuse or I don't refuse. And if you refuse, the consequences to your actions are that they are going to take your license for a year. Not immediately like they tell you. They actually get to lie to you on this. It's not immediately. They give you a piece of paper and it's a 15-day warning that your license is going to be revoked for a year. And in some jurisdictions, they call themselves no refusal counties. Some of them have signs on the walls at the jail, but they're going to tell you, if you refuse, which you have the right to do, when you will potentially lose your license for a year unless you have a good lawyer who knows how to win that case. But they're going to tell you, we're going to ask a judge for a search warrant. We're going to fill out an application, wake up the judge, have him sign a search warrant, and you have the right to say, go for it. Because then they're going to draw blood. They're going to either do it at the station or at the hospital. And then there's so many specific steps that they're supposed to follow properly in order for that blood test to be used against you in a court of law. And we find that dozens upon dozens of times they don't follow the steps properly. And that's another way we win these cases.
Talk about the various penalties for DWI in Missouri.
In Missouri, we have many penalties on DWI cases, and it's going to be very dependent on a few things. One is going to be dependent on how many prior contacts you have with law enforcement for alcohol-related stops, whether it's DWI, BAC, or something similar. And so your number of priors matter. In addition to the consequences around this, circumstances around this particular situation. Like if you were in an accident, if someone got injured, whether it's a small bruise or God forbid, all the way to serious injury or death, those consequences are going to be very different. And as you can only imagine, much more severe with more priors and with injury or death. So the average person is looking at a first-time DWI. They're looking at probation. Worst case scenario, they're looking at 2 years of probation at a minimum for a particular type of probation known as SIS, suspended imposition of sentence. That's most likely what a first-time offender gets in Missouri. Not all the time. There are some jurisdictions that refuse to do SISs on first-time offenders. But for the most part, that's what you can expect. And a good lawyer fights to do better than that. A bad lawyer just says, okay, you're going to plead guilty and get an SIS, which potentially you could have done without a lawyer at all.
Is DWI a misdemeanor or a felony?
DWIs in Missouri can be misdemeanors or felonies, or actually you can have a municipal ordinance violation. If a city police officer pulls you over and it's your first or second offense, it's a municipal ordinance violation. If you are pulled over by highway patrol, it is a state charge. And in different jurisdictions, if the county sheriff pulls you over, it's a state charge or a county charge. Some counties like Jackson County has a specialized court just for county tickets. But it's either going to be city versus you, county versus you, or state versus you, depending on who pulled you over. And then the other way that we determine if it's going to be a misdemeanor or a felony is if there's serious injury or death, those are always going to be felonies in state court. If there's priors on your record, if you have pled guilty to, not ever had a dismissal of, but if you've actually pled guilty to, even that SIS probation where you had a prior suspended imposition of sentence, where your lawyer who doesn't know what they're talking about may have told you it's not on your record anymore, because that's not true unless you did an expungement. And that's a formalized process where you go to court and you get an expungement order from the judge. So unless you did that, your prior guilty plea that they may have told you is not on your record is a prior guilty plea that's going to be used against you. And your third in Missouri, regardless of the time frame, is a felony. And what a felony means in Missouri is we are unable, unless we can win the case or convince the prosecutor to reduce it to a misdemeanor, you are looking at being a convicted felon for the rest of your life without the possibility of expungement, serious consequences for jail. In some jurisdictions, some judges require even a short prison sentence on a third offense. And in some places you can get probation, but regardless, you can't avoid being a convicted felon. And what that means to the men and women of Missouri is that they're very concerned about their gun rights and their constitutional rights that are taken away when they are convicted felons. And that's an example of how you can easily be a convicted felon and lose your gun rights.
How long does a DWI stay on a person's record?
A DWI in Missouri will stay in your record for life. And that includes the kind of first-time offense, suspended imposition of sentence, SIS, that many lawyers mistakenly tell you, and I've even had judges tell my clients, that this will not be on your record. That's not true. What happens is, if you have a first offense, and if you got an SIS, it's not a conviction, meaning there's no points on it, and it's not on your driving record unless you had a CDL at the same time. And if it's not on your driving record, it still can affect you because it was a criminal charge you pled guilty to, and it will become a prior. If you ever got another DWI, you have this prior, unless you do an expungement in 10 years. The Missouri statute allows you to do an expungement in 10 years. You would hire a lawyer, you'd go in front of a judge, and the judge would order this expungement, and you have to qualify for it. And one of the biggest things that people mess up is they don't qualify for it because they got another alcohol-related traffic offense in that 10-year period. So you need to be very clean, essentially. No alcohol-related offenses in that 10 years. There's other qualifications, but that's the main one that most people mess up. And obviously the other way people mess up is just not filing the expungement at all.
Can a DWI charge be dismissed?
A DWI charge can be dismissed. And in fact, at my law firm, that is the number one job. Our number one goal is we analyze every single case from investigation through discovery, watching the videos and reading the police reports, talking to the witnesses, analyzing the crime scene, all of it, analyzing the officer's behavior, analyzing hours and hours upon videos, minimum 2-3 hours for every single case, with all the body cameras and all the dash cameras that exist. And usually there's more than one police officer on the scene. So we have multiple videos, and we can analyze all of that, analyze the science as to why the breath test could be wrong or the blood test could be wrong, and then we can get a prosecutor to dismiss. Judges don't dismiss cases. Judges try cases, and they rule on motions. They find people guilty and sentence people, but they don't dismiss cases. The prosecutor can dismiss the case, and the judge can grant our motions, pretrial motions, that cause the prosecutor to ultimately dismiss the case. But that is how it works. And yes, you can get your DWI dismissed, and that's our number one goal for you.
What should I do right away after a DWI arrest?
What you should do right away after a DWI arrest is call a very experienced DWI defense lawyer, someone who specializes in this area of law, someone who doesn't just do all the other areas of law in a general practice, but someone who has fine-tuned their training and expertise on helping people in this situation, who knows the science, who knows the law, who knows how to win a case, who doesn't look at a blood test case as a, oh, well, you're out of luck. It's a blood test. I can't beat that. Doesn't look at a breath test and say, well, I don't see any way to beat this breathalyzer test. Because there are ways, not in every case, there are times that we have to analyze the entire case, investigation, discovery, police reports, videos, the law, and we come to the conclusion that it's in your best interest to plead guilty, and this is why. There's a chance you could win this issue. There's a chance you could win this issue, but the chance is really slim, and this is why we think so. And so you really want to talk to a lawyer who has that kind of knowledge, that kind of expertise very quickly, because even if you're like, well, shoot, I drank a lot, I wasn't, being very smart, I made a mistake, that doesn't matter. There are times that we can help you win your case or at least amend it or save your driver's license, even if you feel horrible and know that you're guilty.
Should I talk to the police if they're suspecting me of a DUI during a traffic stop?
There are so many lawyers out there telling you not to talk to the police. Do not answer their questions. Just if they ask your name, you have to give your name. If they want your driver's license and your registration or your insurance, absolutely give those things. But do not talk to the police. There's lots of lawyers out there using the STFU acronym, in fact. The reality is, in a DWI defense case, you have that option. You can be very minimal. And if you are intoxicated, and I was just slurring my words 10 minutes ago before I got behind the wheel of the car, I'm going to be slurring my words here. I'm going to appear intoxicated. So then you need to not give them all the evidence against you, and you need to keep your mouth shut. However, in so many of our cases, somebody's had 2, 3, maybe 4 drinks. They're not intoxicated, they're not impaired, and they don't sound intoxicated. They don't look intoxicated. And we want them answering the questions, because what the officer is doing is the officer's been trained to not only look for slurred speech, but he or she is looking for you to be confused. If they say, where are you going to, or where are you coming from, and your answer doesn't make sense in the context of your location in that moment or the time of day, then they're looking for that kind of confusion. If you have difficulties getting your driver's license, they're looking for dexterity of your fingers, because someone who's intoxicated is going to have difficulty either finding it, they pull out a credit card instead of their driver's license, or they can't find their insurance card, or they clearly are having difficulties with the dexterity of their fingers. Someone who obviously slurring their words is a big sign of someone who could be intoxicated. There's alternate explanations for everything that the officer's looking for: the bloodshot, glassy eyes, the slurred speech, the confusion. There's alternate explanations for everything. But if at the end of the day you look and sound intoxicated, it makes it harder for us to win your case. So those are the kinds of cases that it would be ideal if the person didn't say anything. But oftentimes, if they talked, it's how we're winning the case.
What happens after a DWI arrest?
Stephen, I think I already answered that question.
Did you?
Did I not? Maybe it was after a stop. Let me have a drink while you look real quick, because I think I did.
Yeah. Yeah, we can skip that one.
If you want to do it again, I can.
No, that's okay. I'm not too concerned about that.
Well, let's go ahead and do it, because I can be short. I have something I could say.
Okay. What happens after a DWI arrest?
What happens after a DWI arrest is very specific under the law. What happened prior to it is where people often get confused about whether they were even arrested or not. Because sometimes you're on the side of the road, the officer issues you a ticket, allows you to call someone to come get you in your car, and that is still an arrest, but you didn't think it was. But ultimately what happens is your The officer has pulled you over, the officer has asked you questions, potentially done the field sobriety tests, and at the end of the field sobriety tests, typically the last thing that happens is the preliminary breath test if you agree to take it, and then they arrest you. I've had clients refuse all of those things and they still get arrested. In fact, they're more likely to get arrested because they refused all those things when the officer simply said, I smelled alcohol and that's all I had to go on. And maybe you're driving, maybe you were swerving, and that's really all they have to go on. And so they're going to arrest you, and most judges are going to uphold that arrest. What happens after the arrest is they're required to ultimately read you the implied consent law. And that is the law where it says we're asking for your blood, your breath, or your urine. We want a sample of one of those. They're allowed to ask up to two. And they want that in order to finish the arrest essentially and finish the evidence against you. So some people refuse those tests and suffer the consequences of a year revocation. Sometimes the police officer gets a search warrant and gets your blood drawn anyway when a judge issues a search warrant. Or sometimes our clients have agreed, I'll provide a blood test or I'll provide a breath test. And I have had cases where my friend actually reached out to me in the middle of the night, called me and said, should I blow? I ask about 20, 25 questions. There's a lot of questions. And I only ask yes or no questions in case the officer's listening. They're not supposed to listen, but I don't trust that they don't. And so I ask very specific questions. And as I'm talking to my friend, potential client, I tell him, go ahead and blow. And he blows below a 0.08. He's already been arrested, but no tickets issued, no case, no charge follows. He was let go in that situation. The officer was essentially, oops, I made a mistake. And that is how that one was treated. But after an arrest is when they typically ask for the blood, breath, or urine. And also after that is when, sometimes during that, it's kind of convoluted how it all happens at the same time. They will read you your Miranda warnings, where you have the right to remain silent, you have the right to an attorney. If you can't afford one would be appointed for you. And of course, you're not going to get one right then and there in the middle of the night. You're not going to get one unless and until you're charged in court. Because if there's no charges brought, they will not if there's no charges brought, they will not give you a public defender. And if you're not indigent, they will not give you a public defender. You have to hire your own attorney. But ultimately, they read you your Miranda warnings. And the only reason they're required to read you those is because you're in custody, because you've been arrested and you're typically in the police car or in the jail at this moment. And they want to interrogate you or ask you questions that could be used against you in a court of law, incriminating questions. Those are the only reasons they have to read the Miranda. Many people get confused because of television. They think the Miranda has to be read or I win the case, but that's not the situation.
What is an arraignment in a DWI case?
An arraignment in a DWI case is an arraignment in any sort of criminal or traffic charge in Missouri. It's that first and initial opportunity for the judge to read to you the charge that you're facing. It's because of our due process laws here in the United States. You have the right to know what you're being accused of, exactly what the potential punishment could be, and what your rights are. And that's what that's what the judge is supposed to read to you at an arraignment. And typically we want people to plead not guilty and hire an attorney, or if you have your attorney in advance, your attorney will take care of this arraignment for you and plead not guilty for you, so that the entire process of discovery and investigation can occur prior to the decision of whether you should plead guilty or not guilty. Don't ever walk into a court without an attorney and just plead guilty because you think you're guilty, because there's always a chance you can win your case if you hire the right lawyer.
What is a plea bargain in a DWI case?
In Missouri, we have plea bargaining in our criminal cases. We don't have it in our driver's license cases. So in every driver's license case, we go to trial, but that's where we get the ammunition and the evidence that helps us win the DWI case. So we always like to go to those trials because we get to cross-examine the police officer and we get to do our full investigation and discovery in a civil or administrative case. And so that's what we use, because the consequence is the same as if we did nothing. It's a suspension or a revocation of your driver's license. And so in the criminal case, plea bargaining is where a prosecutor and a defense attorney start talking about what's an adequate disposition of your case based on all of the circumstances, based on who you are, your past, your present, your remorse, if there's any issues with injury or some property damage or personal damage, or just your remorse of drinking and driving. If there is any reason that you maybe have a drinking problem that we need to talk to the prosecutor and use it to your advantage, that you are going to treatment. That's typically someone who's beyond a first-time offense. But anything that we find wrong with what the police officer did. I've recently had a case where a police officer was found committing perjury in another case. I'm going to the prosecutor and I'm going to talk about that. You have a case with this officer and I'm going to tear them up on the stand. They have lost all credibility with this court. And so we use everything we can to show the good reasons that you deserve a break, or the good reasons on your behalf, but the bad issues that the prosecutor has in their case. Maybe the police officer messed up the investigation, or we find problems with the breath test or the blood test. Anything that we can use in the plea negotiations, because what our goal is in our firm is not to get a plea of guilty to the DWI. If at all possible, we want you to be pleading guilty to anything but a DWI, whether it's defective equipment, careless and imprudent driving, speeding, anything, or a dismissal, which is our number one goal for all of our clients.
How long does a DWI case take to resolve?
A DWI case can take quite a long time to resolve, and quite a long time in your world versus the criminal justice system world. It's a vast difference. In our world, it's easily 6 to 12 months to take care of a case. And that's because the driver's license case is going to run a lot slower than the criminal case. But in your world, 6 to 12 months can sound like a lot, and it's not a lot in our world. And because there are so many cases, so many cases in the system, so many cases in front of a judge, and there's not enough judges, not enough prosecutors, not enough defense attorneys for the system to move very swiftly, in addition to the fact that for whatever reason, it takes forever for us to receive all of the discovery and all of the videos. And then it takes time for us to watch all the videos and talk to all the witnesses and investigate the crime scene. So it takes some time for us to be able to finally help you close a matter.
Now, you've already answered this one, but it's going to make for a good headline, name of a video. Do DWI cases go to trial?
DWI cases can go to trial. The criminal case can go to trial. When you're arrested for a DWI, almost every single person receives two cases. One is the driver's license case and the criminal case. They're two completely separate cases with different opposing counsel for us. The criminal case has prosecutors. The driver's license case has the Department of Revenue on the other side, and different judges, in fact, and in most jurisdictions. And so, yes, we'll go to trial on the DWI if we have to. But what we're doing is we're going to trial 100% of the time on the driver's license case, because there's no plea negotiations. It's not a criminal case. It's either yes or no. You lose your driver's license or you don't. And so we have to go to trial to convince the opposing counsel to give us what we want, or the judge or the administrative hearing officer. It just depends on what kind of driver's license case you have. But those are always trials. And then the criminal case goes to trial more rarely, because we are allowed to do plea negotiations, and we use the driver's license case and the information we've learned and potentially the win we got for you to help us with the DWI case.
What evidence is used in DWI cases?
In DWI cases, the evidence that's being used against you is every observation that the officer made and everything you possibly said to incriminate yourself. There are cases where the officer sees you driving and they report driving that is signs of someone who's impaired, or actually, to our benefit, sometimes people are pulled over and there was no sign of impairment. They just had a tail light out, for example, or a license plate light out. But nonetheless, they're observing how you're driving. They're observing then the stop sequence, how you stop. Do you stop? Did you stop shortly after lights and sirens? Did you pull over without hitting the curb or swerving? Or did you go for miles like you didn't notice the officer because you weren't paying attention, or they're going to argue that you're intoxicated? And so the stop sequence is very important. The other evidence is going to be used against you is what's called personal contact phase of the investigation. The officer is going to approach the vehicle. He's going to approach you. He's going to be using his nose, his eyes, and his ears to determine all the evidence that he's going to find or use against you that you are intoxicated. And what we love about these kinds of cases is there's so many signs of sobriety the officer just blows off and ignores. And that's what we use against the officers. That's how we win so many cases, is because just by the fact that someone smelled alcohol does not mean you're intoxicated. It's not illegal to drink and drive in Missouri. It's illegal to be intoxicated while driving. And so we are looking at all the evidence against you when it comes to all the officers' observations, and his training, whether he followed his training or not, is very important. Those field sobriety tests, he's supposed to perform them in a certain way. And if he doesn't, we use that against him to try to throw those out or show that he doesn't know what he's doing and that he made the wrong decision when he arrested you. And then ultimately, after your arrest, when they read you implied consent and they ask you for blood, breath, or urine, that's evidence that can be used against you. Your refusal to provide any of those things that the officer asks for can also be used against you in what's known as consciousness of guilt. And we look at those cases, and there's more reasons that people refuse to provide blood, breath, or urine than I'm guilty. That's not always what's going on in someone's head. Oftentimes it's, I'm scared, I don't know what to do, I need to talk to a lawyer, or I don't trust you. I don't trust you, an officer. I don't trust the system. I don't trust the breath test machine. It's a machine. And for a sophisticated person like myself, they don't calibrate the machine properly. They don't maintain the machine properly. And those machines can have errors. We use it against them, but nonetheless, that's the evidence that can be used against you. And then we are looking for all the reasons that the case should be thrown out or amended so that you don't have to plead guilty to a DWI.
Can a DWI charge be reduced to a lesser offense?
Let me start over. A DWI offense can be reduced to a lesser offense. If we don't get the dismissal that we want, which is our number one priority, then our second best result for you is a reduction to something not a DWI. That can be careless and imprudent driving, for example, or it can be a defective equipment, or it can be something else. Maybe you ran through a stop sign, so we ask for the charge to be amended to running a stop sign. But nonetheless, absolutely, your DWI can be reduced by a prosecutor. They have that authority and that discretion. If you have a CDL, there are some exceptions to this rule that make it more difficult for you as a client. But nonetheless, a prosecutor does have the ability to amend a charge, and we take advantage of that every opportunity.
Will I lose my driver's license after a DWI arrest?
After a DWI arrest, you can lose your driver's license. You are going to be given a piece of paper. It's called a notice of suspension. If you provided a breath sample above a 0.08 of alcohol, then you can lose your license. 15 days later, you'll lose it for a minimum of 90 days. If it's your second offense within 5 years, it's a year revocation. Or if you refused the blood, breath, or urine that the officer asked for, you can lose your license up to a year. And that's a revocation as well, 1 year revocation. And if you lose your driver's license, you do have some opportunities for what's called a hardship license, a limited or restricted driving privilege, depending on which kind of case you have. But nonetheless, yes, you can lose your driver's license, and you can have an opportunity to drive on what we'll call a hardship license, which allows you to drive to and from things that are very important. There's a long list of things, but it would include things like your work, your school, kids, daycare, pickup, custody exchanges, hospitals, grocery stores, gas stations, the things that are just absolutely necessary. Nothing that's fun or luxurious, not going to a friend's or family's, not going to your parents' house for Easter, nothing like that.
What is an ignition interlock device, and will I be required to install one?
An ignition interlock device, sometimes known as an IID, is a device that is installed on your car. And if you have a DWI arrest and you're ordered to have an ignition lock device by a judge, or it's a part of your hardship license or reinstatement process of your driver's license, you would have to have it installed on your car. If you have more than one car, you better be driving only the car with the ignition lock device during the period of time it's required, or you will be charged with a misdemeanor. So you don't want to ever be caught driving without it if you're required to, because your car can get impounded and you can be charged with a crime. In addition, this ignition lock device, it will cost you money to have it installed. You'll have to have it calibrated every month at a local, probably the place you had it installed at would do that monthly calibration for you, depending on where you live or work. You find something close to you. And it requires you to blow into this device that's attached to your car, or your car won't start. It also is required to have you blow into it periodically while driving, as opposed to just to get the engine on to start. So, and some of them have cameras and some of them don't. So there's different kinds of them, but yes, chances are if you lose your driver's license in the driver's license case and you want to drive during that period of suspension or revocation, then you're going to want to have and you will need the ignition lock device. There are some people that have to have it, second offenders in particular, and beyond. But the first time offender is typically going to have it for a minimum of 90 days up to a year, depending on which kind of suspension or revocation they had, just because they want to drive during that period. They don't want to not drive.
How do I get my driver's license reinstated after suspension?
In Missouri, to get your driver's license reinstated, you have to follow the steps that the Department of Revenue tells you to follow. And so there's three major things that you have to do, and then there's a fourth thing that some people have to do. The three major things that you would have to do, whether you had a 90-day suspension or a 1-year revocation, is that you have to take the SATOP class, Substance Abuse Traffic Offender Program. You have to, and that can be a minimum of 10 hours. It can be a lot more, various reasons that it can be a lot more time, and a minimum of $500, or it can be more than that. You would have to have the SR22 car insurance for a minimum of 2 years, starting from your date of suspension. Minors don't have to do that. So someone under the age of 21 with the DWI does not have to have the SR22 because they're already the most expensive car insurance in the country. But the SR22 car insurance, which is a high risk car insurance where your agency is promising to provide the Missouri Department of Revenue proof that you're insured every month. In addition, you have to pay a $45 reinstatement fee. And then there are some people that are required to have the ignition lock device beyond their hardship period. So you reinstated on this day, whatever that day is, let's say it's today, and you did your SATOP, you paid your $45, and you've already got your SR22 in place. And you had the ignition lock device because you had a hardship license and you chose to drive during your suspension or revocation period, and now you're reinstated. Some people on a second offense and beyond have to have that ignition lock device for another 6 months, or their reinstatement will not stand and it'll be pulled and revoked.
What is an administrative license suspension?
An administrative license suspension is what it's called when you provide a blood sample or a breath sample of alcohol above a 0.08 blood alcohol concentration. So it can be immediate at your arrest because you provided a breath sample, or it can be months later after the blood test is analyzed by a lab technician at the crime lab. And you get a notice in the mail that your alcohol was above a .08, and they're going to try to suspend your driver's license in an administrative hearing process. So a good attorney knows what to do. You only have 15 days to ask for a hearing. We turn in a piece of paper for you, or you can do it yourself. You email it in and you ask for an in-person hearing or a phone hearing. We always ask for in-person hearings because we prefer that, but we can always switch to a phone hearing if we need to, and the other, it doesn't work in reverse. So we always ask for in-person, and then we try that case. We sometimes subpoena the officer to come to the administrative hearing. We sometimes have an expert at the administrative hearing or an expert report at the administrative hearing. We might show video to the administrative hearing officer, and we're trying to win that case. Because if we don't win that case, then you do have a second bite at the apple, known as a trial de novo, where we file a petition in the associate court of the county of your arrest and ask for an actual judge, not a hearing officer who works at the Department of Revenue, but an actual judge, an elected judge in your county, to hear our case, and we have a full-blown civil trial to try to save your driver's license.
Okay, here's a good question. Will I go to jail for a first DUI offense?
I always get asked by people, am I going to go to jail for this arrest? It depends, but typically your first time offender is not looking at any jail time. The statute requires certain people on a second or third offense to serve some jail, but the first offense in Missouri, there's a statute that says if you have 2 years of probation, you can have what's known as a suspended imposition of sentence, and there's no jail requirement. So what that means to you is most likely you are not going to be looking at any jail on the first offense. There's a very rare exception to this rule. It's your first offense and you were in a very serious car accident with very serious injury or death. That's very different because that's going to be a felony, even though it was your first. But for most people, your first time offense, you're not looking at jail time.
Will a DUI affect my employment?
I often get asked, will a DWI affect my employment? And the answer is it can. There are people who, if you have a CDL, you're looking at losing your CDL for a year. That certainly would affect your employment if you need it to drive for work. There are people that have high security clearances at places that require a background check. And the minute you tell your business that you were arrested, you could then have to go through a process of potentially losing that security clearance. There are people who are licensed professionals like nurses and doctors and pharmacists, and your first time offense is not typically going to cause you to lose your license, certainly. Could it cause you for them to look at you to determine whether this is a chronic problem or, just a one-off thing? Absolutely. But there are reasons that people can have difficulty after a DWI arrest. All the more reason to have a lawyer who knows how to win these cases, because if you're able to say, I was arrested, but I won the case, that's so much better for you and your employment and your future.
What happens to my car insurance rates if I'm convicted of a DWI?
If you're convicted of a DWI, it shows up on your driving record as points, and then you have a point suspension in addition to all the other consequences of the DWI. And that's where an insurance company can see that you have a DWI. They see the conviction on your driving record. And so when the underwriters go to review your insurance, your premiums are most likely going to go up if you're not even dropped, potentially, depending on your insurance agency and your prior history. What does your driving record look like? How many contacts have you had with law enforcement for DWI? The higher risk you are for the insurance company, the higher your premium is going to be, and the chance of them dropping you are going to increase. So every opportunity that we have to win the driver's license case, win the DWI, and keep this off your driving record, it's better for you. They're not going to know about it unless and until it shows up on your driving record. There are other ways that a DWI can affect you, but specifically people tend to ask about, what about my insurance?
Will I have to attend alcohol education programs?
There are alcohol education programs in Missouri that are required in some of the criminal cases and in all of the Department of Revenue cases if your license was suspended or revoked. In order for you to have your license reinstated, you have to attend what's called SATOP, Substance Abuse Traffic Offender Program. And that is a class that's a minimum of 10 hours and $500, and then it can go up to all the way to inpatient treatment, depending on your priors, depending on the blood alcohol content level. They interview you and ask you a lot of questions about your drinking. And so you're placed into a particular level. If you're curious about what SATOP is in Missouri, just Google it. There's plenty of information on the internet about what SATOP is, what all the levels are, and what they cost, because it's regulated here in Missouri under the Department of Mental Health. So yes, there's alcohol programs required after a DWI arrest in certain circumstances, certainly in your driver's license suspension or revocation, and in some of your DWIs, it's the same class. And so you would only take it once. If you're required to take it in both circumstances, you just take it one time after your arrest.
Will I be able to travel outside the country?
Being able to travel outside the country is a question we often get. And frankly, it's shocking how difficult it can be to travel outside the United States if you ever pled guilty to a DWI. And that includes our suspended imposition of sentence, SIS, type of probation for a first-time offender. Certainly, if you were convicted and it's on your driving record, that's even more serious. But even someone who did the SIS, meaning they weren't convicted, they received no points, and it's not on their driving record, that guilty plea alone can prevent you from going to places like Canada, Australia. There are plenty of countries. You'd have to research it for all of the countries that find this a reason to refuse your entry into their country. There are ways around it. For example, I have friends who are lawyers in Canada, immigration lawyers, who help our clients get into Canada. You want to go on that fishing trip in Canada? Absolutely, but you better prepare in advance, because you can and will be trying to cross the line into Canada, whether it's on a plane or by car, and they're going to turn you away if you did not take the necessary steps to enter their country legally.
Can prescription medications lead to a DWI charge?
Prescription medications can also lead to a DWI charge. Driving while intoxicated in Missouri is driving while intoxicated by alcohol, illegal drugs, or medications, or a combination of those things. And so I have seen cases where people were charged for taking their prescription and admitting at the arrest that, yes, I take anxiety medication. I'm on Xanax, for example. I take one pill every night, and the officer just jumps to the conclusion that you're intoxicated. They don't give you the benefit of the doubt. We have to fight so hard by using a toxicologist, using experts to show that more likely than not, someone who's on a prescription, unless they're abusing it and taking way too much and actually becoming impaired by that medication, chances are that medication is regulating them to a place where they're safer to drive because they're on it. And we would not want them on the road without it. Those are more, that's a scary situation. I've also seen in Missouri at least 2 cases where a prosecutor charged someone with driving on Benadryl. And in both cases, the person was found not guilty. One was by a jury, the other one, I think, by a judge. And Benadryl is just an allergy medication. There's a warning that you might get a little sleepy, but it's not illegal to drive while sleepy. Even though it's more dangerous than driving while intoxicated, it is not illegal to drive while sleepy. And so just beware that if you're on medication and there's any sort of feeling of impairment, like I shouldn't be driving, then you should be safe and not drive. In other words, don't risk it.
How hard is it for the state to prove a marijuana DWI?
Since marijuana has become legalized in Missouri in the last few years, we're seeing more and more what we'll call DUI cases, driving under the influence of marijuana. And what we are finding is that law enforcement is not very successful at doing a proper investigation of showing that someone's impaired or intoxicated on marijuana. Neither is the blood test that they ultimately get, because there's no breath test to determine that you have marijuana in your system. So the only way they're going to know you have marijuana in your system is if you admit it and say, yes, even if it was the night before, I use a gummy to sleep, and now we're talking 8 a.m. the next day, they're going to find marijuana in your system. But that doesn't mean they're going to find enough marijuana in your system that you're impaired. And the period of impairment, according to the science, is so small. In fact, there's studies out there that there's really no impairment to drive by marijuana. That actually, it's strange, but a lot of people drive better and safer while on THC. And that could be because they have high anxiety. That could be because it's relaxing them. They're self-medicating, just like they would be on a prescription of Xanax. And so it is very difficult for the government to prove a driving under the influence of marijuana case in Missouri as the law stands now and as the science stands now. And there are unfortunately many lawyers that don't know this, and they're just pleading people guilty left and right to driving under the influence of marijuana. Do not talk to those lawyers. Talk to a lawyer who knows how to fight this kind of case. My law firm knows how to win those kinds of cases.
Yeah, probably should have. This would be a good headline. Can a DWI be expunged or removed from my criminal record?
A DWI can be expunged from your criminal record, and that's only if you qualify. And how you qualify in Missouri is that your first DWI defense, your first DWI offense that you pled guilty to, if you went 10 years after that guilty plea without getting another DWI or having another alcohol-related contact with law enforcement, you there's other qualifications, but typically that's the big one. You got to basically stay clean for 10 years. Clean from a speeding ticket? No. Clean from, even a car accident? No. But clean from alcohol-related contact with law enforcement? Absolutely. No more refusals, no breath tests above 0.08, and no DWIs or BAC charges, certainly. And then you hire an attorney, you go into court, and a judge orders an expungement of your DWI. And it's as if it never happened. It can't be used against you in the future in a criminal case, and it certainly can't be on your driving record anymore either.
And then there's a couple questions here that will be.
Give me one second. I'm gonna. My dog just got back from his walk, and can you hear him on the recording? Because he's very loud to me, panting. Let me just get him outside this.
Yeah, go ahead, because you'll be more comfortable if you do.
Yeah. Royal, come here, buddy. Come on. Good boy.
And just two questions left.
Whoops. What happened? It turned. Okay. I'm trying to avoid those ropes being seen, but for some reason it's.
You had the there. That's, I think, your best
yeah,
shot.
But the ropes. You can see all those ropes, and before I couldn't.
Yeah. Now that you point them out, I see them. I don't know that people are going to notice them.
I don't know what happened.
But
shoot, give me 1 second. There.
Okay.
So I don't mind these strings from my shades, but the ropes, oh shoot, now the camera just completely moved on me. But that's okay. We're still happy.
Like my dad always used to say, it's always something. It's always something,
I'm back to being in the right spot.
Okay. Really, two more questions. Again, you've answered them, but these make for good video titles. Can DWI test equipment malfunction?
The DWI breathalyzer machine can absolutely malfunction. Here in Missouri, we don't calibrate it often enough, according to the science. We do not maintain our devices like we should, and we get away with it because there's a regulation that says they only have to be calibrated or maintained every 35 days. And in other states, it's much more often than that, some daily. And in other states, they're required to do a breath test, 2 breath tests per person, because it's the same concept as if you're a carpenter, it's measured twice and cut once. It's the same concept with breathalyzer machines. If they only took one sample, how do they know it's accurate? If they took two, took one and then another one a little bit later, chances of them being similar and then they know it's more likely accurate than they do if they just took one. And another thing about Missouri is the science. There are scientists out there that we consult with all the time on our cases who say, I cannot believe that your state gets away with this because a machine that is taking in alcohol and claiming to test the alcohol in your lungs and essentially spit out a number on a ticket that says your blood alcohol concentration is this number should be required to clear out that device and do a maintenance check after every breath sample that was taken. And in our state, it's every 35 days. And there are scientists out there that say that's absolutely ridiculous.
Hmm.
And there's other reasons that devices can be off. There's people that have GERD or diabetes, and that can affect the breath test result. There's people that have COPD that makes it nearly impossible for them to provide a breath sample. We also have experts who will tell us that if the officer tells you to take a deep breath and blow really hard and the way they coach you to blow can be wrong and cause the breath test result to be higher than it should be. So there's lots of reasons the breath test device can either malfunction or the officer does something wrong. We had a case or a city, a particular police department that had during COVID, they had alcohol sanitizer, hand sanitizer with alcohol in it right there next to the machine. And they would clean their hands with that, grab a mouthpiece, put it on the hose and put it into our client's mouth to blow. That is absolutely going to be a problem with the breath test because the breath test device is reading the alcohol in the air. They're looking for ethyl alcohol. And then there's devices that don't have what's called well, I don't want to go into the science of it, but there is a particular kind of device that's approved here in Missouri that can be used that cannot detect mouth alcohol. In other words, if you have mouth alcohol in your mouth and you waited 15 minutes like you're supposed to, the officer waits 15 minutes before from your last sip of alcohol or water or gum or chew in your mouth or whatever it was to before you provide that breath sample. The alcohol in your mouth is supposed to evaporate, but it doesn't always happen. I've had clients with dental work. I've had clients with dental work with cotton in their mouth. I've had clients actually blow into the breathalyzer with chew that the officer didn't see or ask them about in their mouth. And that anything that's holding alcohol can bypass the machine, and the machine's supposed to say there's alcohol, mouth alcohol, we detect a problem here, and reject the sample. There is one device here in Missouri called the AlkaSensor 4 that does not have, it's called a slope detector. It doesn't have the slope detector to prevent a false positive like that. So there's tons of reasons a breath test can be wrong.
What is a chemical test?
A chemical test is when an officer is looking for blood, breath, or urine to determine your blood alcohol concentration or if there's drugs or medications in your system. That's all a chemical test is. And in Missouri, they're admissible against you. The results are admissible against you, but there are regulations and then the science that determine whether that test should be admissible at all or whether it should be relied upon, whether there's mistakes and errors in the breath testing process, whether it's human error or machine error or process and systems error. But that's what a chemical test is, and that's how it's used against you.
Okay. Think we can stop the live stream.